Hi. Okay, let me mark this. Good morning and welcome to the Coalition of California Welfare Rights Organizations presentation on California Department of Social Services state hearings. We're calling this 101. We hope to do more in the future. My name is Daphne Macklin. I'm the researcher at CCWRO, and I'm being joined in this presentation by Grace Gallagher, who is our litigation director. You want to introduce yourself, Grace?
Good morning. I'm Grace Gallagher. I'm glad that you can join us this morning.
Okay. So we are going to run for about an hour and a half. We may actually run a little bit shorter, but we are very happy to have you here. And we hope that this presentation is both enjoyable and informative. There will be a follow-up packet, which will include the presentation and some other documentation that will be helpful for you if and when you have the opportunity to do a hearing. And I expect we have a range of experience. So let's get started. Next slide, please. So this presentation will focus on administrative fair hearings as done by the California Department of Social Services. That is, for the most part, fair hearings concerning CalWORKs, concerning the CalFresh program, in the programs that come underneath that, as well as some medical hearings in home support services hearings. What is important about an administrative fair hearing is it is the only method by which a claimant or applicant can challenge an action that has been proposed by a county welfare department to either not grant benefits, to reduce benefits, or to terminate benefits. It is also the only way that a claimant can act to get a county to respond when the claimant has asked a county to take a particular type of action. For example, increase benefits because there has been a change in household size or a change in composition, or say a loss of household income. Next question, next slide, sorry. So the most important people at a fair hearing are the following: the claimant or the applicant, and the claimant may actually be self-represented. This is what happens in many instances, and sometimes you will just be called upon as an advocate to advise a person how to proceed to a hearing. On the other hand, it may be a complex hearing, or a claimant may not be able to adequately represent himself or herself, and assistance is needed. And a claimant is entitled to choose whoever he or she likes to be their representative. However, they are entitled to have a representative, and they should not be discouraged from having one if that's what they want. The next important person is, of course, going to be the representative. And then there will be the county representative. This is an employee of the county that has taken the action, because you will sometimes have a case where you say are in San Francisco County, but the action took place in Alameda County. So Alameda County would be doing the representation. The county representative's job is to represent the county's point of view and present the case from the county's perspective. The next most important people would be any witnesses for either the county or for your client or you, the advocate. And finally, there is the administrative law judge. That person is an actual employee of the state of California, specifically the California Department of Social Services and the State Hearings Division unit. And that agency, SHD, is responsible for the actual administration of the hearing, the issuance of notices, the collection of information.
So what the counties generally do is the program, the operation of the claimant's case lays within the program. So once the client requests a hearing, the county representative is assigned the case, but she's in the hearings unit. So it's an entirely different unit of the county welfare department. And the county rep is generally not an attorney. So it's usually a lay person with a lot of experience and knowledge within the program that she's going to be working in. Next slide, please.
The most important decision at this point in time is to determine whether or not the claimant is going to request a hearing. The first document that needs to be reviewed is the county's notice of action. This is a primary source, and it's very important to have this written document. If there is not a written request for hearing, that's a problem, and the county should be asked or directed to provide a written statement of what it is deciding to do. Very often a client will come to you and say, well, they told me I wasn't eligible for CalWORKs and they wouldn't even let me apply. That is not allowed. That needs to generate either a written notice of action, but it can certainly generate a request for hearing. You want to interview your proposed claimant or client and find out from them what happened, when, how, where. You also want to determine if the proposed action on the part of the county is factually correct. So there is an actual written notice of action. It states that the household is not eligible for CalWORKs benefits because it is over income. There is more income than is allowed for that program. The notice of action should also determine if the county's action is legally correct. So if the notice of action says you have excess income, is that accurate? In the hypothetical that we're going to talk about a little for this part of the presentation, Mary A. Smith is a grandparent who lives in the household. Mary M. Smith is your client. The claim from the county is that Mary A. Smith has excess income. The facts are that Mary A. Smith is a senior. Her income is SSI. It is not counted for the CalWORKs program. So the county's conduct is both factually incorrect and legally incorrect. One more point I want to make. There are occasions, very rare, where you do not have a right to a hearing. And those instances are often when an action is being done statewide or it's something that cannot be helped. So watch out for that occasional rare instance, but it will occur and you do want to pay attention. Grace?
The other time that you can request a hearing is when you have, the claimant has asked for services or an exemption or a waiver or welfare to work, supportive services, and the county has done nothing. They don't send out a notice of action, they just sit on it. At that point, you can ask for an administrative hearing to challenge the failure of the county to act. Sometimes they will, the person will call the county instead of filing for a hearing and then talk to the county for a couple of weeks, and the action is still taken by the county. And at that point, you can ask for a fair hearing as well. Next screen.
Now, once you have an actual notice of action, it's important to determine if that written notice of action is legally adequate. And there is a volume of regulations known as the Manual of Policies and Procedures for California Department of Social Services. And at section 22-001 L1 is the definition of what constitutes a legally written adequate notice of action. Obviously has to be in writing. 2, it must inform the claimant of the action that the county intends to take with respect to their case, with respect to the particular program. Can't just say we're cutting you off of all of your benefits. Can't say that. It must also state the county's reason for the intended action. You've gone back to work, you now have earnings income, that now puts you over the earnings limit for your household size. It must also state the specific regulations supporting the county's proposed action. And this will be a series of letters and numbers at the bottom of the hearing notice. It's worth taking a look at that because often it's not the specific and appropriate regulations, and that's grounds for challenging the NOA. Finally, that written notice of action must specifically advise the claimant of the right to a state hearing. And it must also advise that they are entitled to receive the notice in the language that they speak, if it is not English, and provide appropriate accommodations. Grace?
The notice also needs to talk about the effective date of the action. It just cannot say that we're cutting you off immediately. You have to give, in most situations, at least 10 days advance notice of the action that the county proposes to take. Now, the action can be something as simple as when aid is granted. The NOAA would also issues when the aid is decreased, increased, even when it remains the same, or when benefits are stopped, or when your application is denied. You also have the right to have a hearing when you're denied CalWORK's immediate need. And for purposes of CalWORK's notices of action, look at All County Letter I-02-14, and that should help you as well. Thank you.
Next slide. Now, a little bit more background on the adequate notice of action is that it must state if there is verification missing or information needed. It has to tell the claimant what is needed or missing. We need a driver's license. We need a copy of your bank statement. The county has a duty to assist in helping obtain verification. So they need information about an employer. They may need information about where a child is enrolled in school. These are all things that counties have an obligation to assist with, whether or not they want to. The language is also very critical. Mentioned it before, but again, it's very important for people to receive notices, especially if they've given the county information about what their primary language is. There are, I think, up to 17 languages for which some documents have been translated. Grace, you have some more information on this?
Yes, so you can find a list of the translated forms and publications on CDSS.ca.gov, translated forms and publications. And it will show the forms and notices that have been translated, as well as a breakdown for the languages themselves. So if you want to look at Armenian language, you can go to the A's and find the Armenians. And if the county has translated a form in a particular language due to the population size of the immigrant or the individual, if they have to use that form for everyone who speaks that particular language. If CDSS has a mandated form, the county must use it. So if there is a form that's been translated into Russian, the county cannot use an English language form. The other thing that I'd like to point out at this point is that California Public Social Services is transitioning into CalSAWS. Most of the counties now are CalSAWS. The notices of action that are being used by CalSAWS was approved by the counties and not necessarily reviewed by the state of California. So I advise you that when you get a CalSAWS notice or any other form, you go on the DSS website and check the official form and compare the two. And if the county form being used is different than the state mandated form, then you need to challenge that notice or form. And I mean, there's some people that some forms will ask for information that is not necessary. And if you don't give the correct answer, you can be sanctioned. So be very careful with that.
Next slide. The next most important decision that you as the advocate will assist your client in making, prospective client, because you may decide not to take the case, is this question. Should this client ask for what is known as aid paid pending? Aid paid pending very simply is defined as a continuation of benefits that are scheduled to be reduced or terminated at the level they are at the date of the receipt of the notice. Basic things to remember about aid paid pending. You must make the request for aid paid pending within 10 days of receipt of the notice of action, and certainly, if at all possible, before the termination or reduction of benefits is to occur. Now, it is important to remember that if at the hearing, the administrative law judge upholds the county's action and states that, yes, this household was over income and resources and therefore was not entitled to have their benefits continued, then anything that was received after the date of the termination on the notice of action will be considered an overpayment. So you have to consider the facts very carefully and discuss this with your client, whether or not they want to ask for the aid paid pending or just proceed with the hearing without additional funds. It must be the claimant's decision. This cannot be something that the advocate decides, oh, you need to get this, we're going to win this case. You can't make that prediction. The relevant information to look this up within the DSS information is MPP section 22001A7 and ACIN I02-14, which will be in the packet that we will send you. So, very simple example. If a person receives a notice of action that's dated September 23rd of 2022, it states that the household's SARS 7 document, the semi-annual reporting of income, was not timely received, and that CalWORKS will stop for that household on 10/1/2022. Something of a problem because that's less than 10 days. Now, this is a SARS timely reporting problem, happens a lot. This is something that you might be comfortable asking for aid paid pending, but you definitely want to ask for a hearing as quickly as possible, which would be within 10 days and which would allow aid paid pending to be paid if that was your client's wish.
There's one note is that there is no aid paid pending for supportive services and welfare to works. So like transportation, payment of books, they would not be continuing to pay that.
Aid paid pending is also not available if yours is a new application for assistance in a specific program. So it's important to consider There is a very distinct difference between a person who's an actual recipient of benefits, who's asking for aid paid pending, and someone who is a new applicant for a new or a different program. Next slide, please. The timelines for requesting an administrative hearing are very important. We've just gone over one of them, the 10-day rule for aid paid pending. The general rule is the request for hearing needs to be made 90 days from the date on a legally adequate written notice of action. So it's 3 months. That timeline is extended to 180 days if there is good cause for any delay. The example that I use for those of us here in California, there's been some type of natural disaster. There's been a fire, there's been a flood, there's been a landslide. Any of those are practical problems that can make it very difficult to comply with the 90-day rule. Can also make it very difficult to comply with in the event of the loss of the housing for the claimant or the beneficiary, or as many of us noticed during COVID, the unexpected and untimely shutdown of a county welfare office or agency. Now, you are allowed to make a request for hearing through the state of California, but good cause is good cause, and things do get slowed down. Now, the last line of defense is if the notice of action, a written notice of action, is not legally adequate, then a hearing may be requested at any time. Now, this isn't exactly without bounds. There are some levels of reason. So you want to request the hearing as soon as possible. If there is any need for a delay, you want to explain that as simply as possible, and do expect some pushback from the county. Grace, did you want to go into that a little bit more?
Yeah, I mean, one of the issues that will determine whether the notice is adequate is that you have to have all specific facts and information must be contained within the body of the NOAA. So if the county sends out a NOAA saying you have failed to report your employer's income or your income from your employer, and there are 2 people in the household that has income, and maybe one of the members has 2 or 3, that is not an adequate notice, because you have to identify which member of the household has failed to report and which employer has failed to report. So then if the client calls the worker and says, I don't understand the notice, and the worker then says, oh, well, it's your husband's income that we don't have, they will then go into a hearing and say, oh yeah, the notice is adequate because we verbally informed the person whose income was missing, and we gave additional facts so that the client knew what was being requested from them. That is not an adequate notice. It has to be, as I said, it has to be within the body of the notice of action to be legitimate.
Next slide. Now, when it comes to making the decision to request the hearing, our advice is to make the request through the Department of Social Services. And you can do this by telephone, you can do it by fax. I believe there's an email process as well. You get to make some decisions at the beginning, and you may want to think about them over time. For example, does this claimant want an in-person hearing where you go into the welfare office, you sit in a little room, if you're lucky, and there's the judge and there's the county, and You kind of do it all together like we used to do before 2020. For many years, it has been possible to do hearings by telephone. And since COVID, the use of the online computer-based hearing has grown rapidly in popularity for a number of reasons. You can sometimes get a hearing more quickly. It's often easier to appear by telephone or online as opposed to traipsing down to the county welfare department, especially if you are in a county that only has one place in the county where they do the hearing. So it's not a decision you have to make immediately, but it's something to think about. You also want to think about whether or not you want to request accommodations for disabilities. Well, you're entitled to that. You should make that request, but you do want to talk about that with your advocate and with your client to see what works best. Then there's the need to request an interpreter if that's needed. I tend to feel that having an interpreter is helpful. Sometimes the language is very simple and straightforward, but sometimes it's very confusing. And your client is allowed to make the best showing possible. So this is something to think about. It's important to make that request as soon as possible, timely, or if there's an opportunity to discuss with the county how to set up for the hearing, getting those things done. Grace?
The other issue is when you are requesting accommodation, it's just not including the physical. It can include if you have a client who is allergic to smells, you can request everybody not to wear their cologne, deodorant, anything that would cause the person to get sick.
Yeah. Next slide, please. There are some rare instances where a claimant may request an expedited hearing for certain emergency situations. These are for those programs that provide expedited benefits. And it's important to use the right language because different programs have different terms that mean emergency or expedited. So expedited CalFresh is one of those emergency situations for which an expedited, faster than normal hearing may be requested. Also, immediate need CalWORKS. Also, denial of CalWORKS supportive services, denial of CalWORKS homelessness assistance obviously is going to be something of an emergency. It can also apply to any other issues of urgency. For example, a need to have IHSS benefits granted promptly because your grandfather has died, your grandmother now needs to have someone other than your late grandfather serving as her IHSS provider. The household is entitled to at least 10 days written notice of the date, time, and place of the emergency or expedited hearing. And for more information, there is ACL 1340. Grace?
So if you need to have your client file for an expedited hearing, you can call 1-800-952-5253 to request an expedited. You generally, the expedited is probably about 30 days maximum, whereas a hearing decision can be up to 45 to 90 days.
Next slide, please. Now, the key agency that you will be working with, in addition to the county welfare department that issued the notice of action, or the county where your client is now living, and that can get a little dicey, is the California Department of Social Services State Hearings Division. SHD, as it's known, is responsible for the administration of the fair hearing process and processes. We recommend that you notify the state, and that would be SHD, if you are requesting a hearing. SHD's responsibility is to notify the county that issued the notice of action, to establish a case file in SHD's ACMS computer system. The ACMS computer system will allow both the claimant and the AR to access the computerized files for their specific case. It will obtain the county's statement of position, it's the SOP, and counties now upload that SOP into the ACMS system. And it is the way, using the ACMS system, is how you as the advocate for your client or self-represented client will upload information themselves, and most specifically their statement of position, any documents for the hearing, any documents that are being shared between the client and the county. The website information is here on the screen, and please make a note of it, and also visit the ACMS site sometime when you're not doing a case so you can get somewhat familiar with it. Grace, anything to add?
Yes, so when SHD receives the notice of action and they contact the county that the hearing has been requested, there are two alternative tracks that may occur. One is an administrative dismissal, which is the state hearings can on their own behalf propose to dismiss the hearing request without holding a hearing. And the reasons for that would be if there is no jurisdiction to hold a hearing request was filed late, the issue was subject to a previous state hearing, there was no standing to request a hearing, and that often occurs when the claimant's competency is at issue, or if a friend is requesting a hearing on behalf of another friend, but without being an authorized representative, or if there has been a compliance issue. And that is if the claimant has gone through the hearing, but they disagree with how the county complied with the hearing decision, there is no hearing available for that compliance. So when the SHD decides to file or do a dismissal, they must send a letter and give 15 days written notice requesting a written response as to why the administrative dismissal is incorrect. Alternatively, when the county receives the notice of action of the hearing, they can request that the case be bifurcated if they believe there is no jurisdiction. And it would be, again, you should be able to bifurcate if the issue is what, again, generally it's within, it was an adequate notice of action and you didn't file timely. State hearings can also request a bifurcation on their own behalf. You can oppose the bifurcation request, and if you do oppose it, then you will have a case established in ACMS, and the hearing will be just on the jurisdictional issue alone. So that if you do win the bifurcation issue, then you would go back and have another hearing on the merits of the case. Proceed.
So the SHD responsibilities include setting the time and the type of hearing for the case, identifying issues in the written notice of hearing at least 10 days before the hearing, this is something that you will be doing. You, if necessary, should contact SHD if matter needs to be postponed. So it's set for the 20th of November. That's a date that your client has had long scheduled surgery. Obviously, the 20th isn't going to work. So for most programs, one postponement without cause is allowed. There may be pushback, there should not. And you may need to postpone because the county has not produced its statement of position within 48 hours of the hearing date. That is an automatic postponement. It does not count against the claimant. It doesn't really count against the county either, but it is a reason that cases are being, may be postponed. Now, I would also say that there's some documents that you need to make sure that you get to SHD. And first and foremost would be the DPA 19, the authorized representative statement on the DPA form, which is from the State Department of Social Services. A written note that says, I, Jane Smith, want my nephew, John Smith, to be my authorized representative should be adequate, but sometimes they insist on the right documentation. Grace, anything to add?
Yes, the postponement can be made either before the hearing or at the hearing. For example, if the county has submitted an SOP 2 days before the hearing, and then on the day of the hearing, they give you a supplement, that is basis for asking for a postponement for new information. The automatic postponement occurs if the notice is defective or that they that the county requested a postponement to begin with. After the first postponement, you need good cause, as Daphne said, and you will need to submit the verification of good cause. For example, illness, death in the family, the authorized representative is unavailable due to scheduling conflict or out of the area for good cause. The department is now saying that any postponement request after the first must be in writing. That's it.
Okay. Next slide, please. The responsibilities of the county welfare department are, as one would expect, extremely critical. The county, where that has issued the notice of action, is responsible for assigning a specific county representative or a county staff person for the hearing. As Grace noted previously, this is usually someone who is senior in the department, who has experience with a particular program. For example, they worked in the IHSS program, so they understand that program. They've worked in eligibility for CalWORKs, so they're familiar with those issues. They're familiar with food stamps. This is a person who is generally not familiar with the case if you are in a larger to a medium-sized county. If you are in a smaller county, there is some chance that there may have been some overlap with this worker and your client. It's just the way things work. I've worked in both large and small counties, and usually the people who are working as county representatives are far enough along and far enough distance that they will bring a certain dispassionate relationship to what has happened in a case. These are usually supervisory level people. That county representative will review the entire case file, as much of it as he or she can find. They will speak with the worker or workers who have handled the case, including any investigators, say, from the fraud unit. They will try to talk to your client. Now, if your client is represented, then they can very easily say, or seems easily, but they should be counseled and advised to say, no, I have an advocate. I would like you to speak with my advocate. And that's when they'll be asked, okay, yes, this person signed a DPA 19. Yes, they have, check on ACMS. The important thing is to cooperate, but do not roll over and play dead. The other thing is to listen to what the county has to say. It's always surprising when the county worker gets in touch with you as the advocate and goes, there were a few mistakes made on this case. What would you like to talk about? Grace?
In addition to talking to the claimant, you need to tell them not to say anything either to the county representative working the case, to a fraud investigator, or any other county worker that may contact the claimant regarding anything about the claimant's particular case, because that is how you get in trouble with fraud, and that should not happen. In addition to not talking to the county welfare department after talking to the claimant, you need to warn the claimant not to talk to anyone about this issue. Because if you have a claimant that talks to a friend, you need to be aware of the fact that the county may find that friend and use that friend against the claimant. Also, you don't put anything on any Facebook, Twitter, anything that would cause the county to be aware of potential damaging evidence.
We cannot highlight this enough. We are both attorney advocates, so we bring a level of ethical and professional responsibility to the relationship, even though this is a civil administrative hearing. These hearings have consequences. Your client may not appreciate that. If you are an attorney advocate, you clearly need to lay that out for your client as specifically as possible. This isn't television. This is the real world. I had the experience of actually interviewing some clients some individuals who are going to be witnesses in a hearing. And it turned out that one of the individuals was actually brain injured. She would not have been a good witness for my client, and was certainly not a good witness for the county by the time I finished with her. Next slide. When it comes to preparing for the hearing, you definitely want to set up a notebook. You definitely want to set up a file folder. You want to review the notice of action again carefully. If you are working in a unit, you want to review this with your unit. If you're working by yourself and you're relatively new at this, you want to have a mentor or support person to go over things with, just to make sure that you don't miss anything. You want to identify the evidence that supports your client's position. And you want to interview any potential witnesses, and then you want to attempt to review the county's case file. In fact, you kind of want to insist on reviewing the county's case file. So to use the hypothetical that we started with about Mary A. Smith, the grandmother on SSI, who has a bank account that the county welfare department is claiming is a resource that's available to her daughter, the CalWORKS recipient. Clearly, you were going to want evidence of Mary A. Smith's bank account, how long she's owned it, how many years she's had it, although not necessarily what's in it. It's hers. You want to interview grandmother Smith as well as her daughter. There may be someone else in the house For example, who knows? Oh yeah, that's grandma's bank account. You know, she doesn't let anybody touch it. She doesn't let anybody touch her card. And you want to review the county's case file, because often in a case like this, and I actually did have the case where my client was Mary M. Smith and Mary A. Smith was her mother. And because they were using the same address, the county thought this was the same person. So it was useful to get a hold of the county's records, the application, and they're listed as a member of the household whose income didn't count was the grandmother, Mary A. Smith. So often it's easy to resolve cases when you can actually see what are the documents and look at them carefully. Grace?
Don't exclude potential sources of evidence. For example, if you have a claimant that has a notice of action for an overpayment because they failed to report income from Chico, and at the time of the said employment was actually in class at Sac City, you need to think about getting a declaration from other students within the class, from the professor, and attendance records that demonstrate that the claimant was not in Chico at the time. And you need to think outside the box. If there's other reasons, for example, if the person was at the doctor, get statements from the doctor, you know, of the records of the attendance, and any other thing that you can think of that would disprove the county's case.
Next slide. You want to gather any documents that you want to present at the hearing. And not only do you want to gather them, you want to identify them, you want to verify their veracity, their accuracy, their sources, and have them prepared to upload into a CMS. We were just talking to one of our colleagues who's actually taken to submitting individual items of evidence along with the statement of position. You don't necessarily have to do it that way, but you know, the case may demand it, especially if it's a very fact-intensive case. You want to draft an outline of your opening statement and your closing statement. Everyone has to do an opening statement. Your Honor, this is what the case is about. The county's wrong. Okay, not quite that bold. But your closing statement, you do want to identify the key facts that you presented at the hearing, why those key facts are important, and why the ALJ should rule in your client's favor. Now, you may have to change what is in your outline depending on what evidence shows up for your case and what evidence is presented at the hearing. Testimony may change or be different. And the ALJ will himself or herself often make statements or have questions that need to be answered and may need to be responded to or reaffirmed in your closing statement. Grace?
One of the things that you have to do is talk to your client multiple times, asking basically the same questions. Because if you get a different response each time, you're going to have issues at the hearing. And one of the things that you would have to do is once you talk to your client and finally get the facts down, you need to compare what the client says with what the witnesses say. And if there's a difference, then you need to get those things resolved. The other point is that if the ALJ statements or questions seem pointed with regard to being pro-county, then you need to be able to address and counter the the statements, modify them. If the ALJ seems to be adopting a mischaracterization of the evidence that the county presented, you must actually go in and say, Your Honor, da 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 da, and make a pushback on what the ALJ is believing.
Just to follow through with what Grace is saying, if it appears that the hearing officer is biased, rather than actually challenge that, you need to start carefully taking notes and establishing in the record where the bias occurred, where the problems are coming up. Some judges are cagey, they don't really let you know what they feel, but others are a little bit more blatant. They may actually not have an understanding of an issue. For example, the difference between a person who's brain injured and a person who's developmentally disabled. So these are things that you need to make a record of and make note of, because you will be using those if you are making a request for rehearing, or if the decision is made to take your case up, this particular case up on a writ. Next slide. Now, we've stressed talking to your clients. I will add in a wrinkle that will happen from time to time. The client who is very, 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 very talkative, as long as it's you and her or him. When you get into the hearing room, you couldn't get that client to say anything. It happens. So this is a client where, if, get from them honestly, are you going to have a problem testifying? Because if you are, that is an individual that you may need to do a declaration for and explain. My client has a bad case of PTSD and may not be able to get everything out. It happens. Now, often the issue happens with witnesses, and you can ask a witness to come to a hearing, but that's not any kind of guarantee they're going to show up. So within the SHD system, it is possible to request a subpoena. It's a civil subpoena. Person doesn't show up, heaven knows how you enforce it, but at least you can do that. But you can talk to a witness. Let's say there's a niece who knows very much that Mary A. Smith is the owner of that Bank of America account. Why does she know? Because once a week, I drive my grandmother to the bank branch, and she's friends with the manager, and so I know that this happens. So will you come to testify for that? Well, I'd like to, but I just started this new job and I don't think I can just get the day off. So that's a person that you would arrange to get a subpoena for. The state of California pays the witness fee. I would say that if you are requesting a subpoena, you have to be able to establish that this witness's testimony is necessary and fundamental to the proceeding, and you don't want to ask for it the day before the hearing. You get enough notice of when the hearing will occur that you can promptly make that request to SHD for a subpoena. Now, what will also happen from time to time is a county in its statement of position will identify 4 or 5 different people who may have handled the case. But when it comes to the actual hearing, that person isn't there. This could be a problem for you. It's definitely a problem for the county. And the ALJ may decide, okay, I really need to hear from the social worker who had the case and then apparently was fired because they kept making mistakes with that case. That might be someone that you want to subpoena. Now, moving on. Now, the next most usable form of evidence would be a statement signed under penalty of perjury by the person that you are not able to call as a witness and for whom you may not be able to get a subpoena. There is a format for declarations. You can get in touch with us. So we'll explain how you want to use those and how they should be put together. Again, this is not the best evidence, but it may well be good evidence that the ALJ will want to take into consideration. And remember, the administrative law judge has the authority to, if they're really intrigued by testimony about all the mistakes that were happening with a certain set of cases for a period of time, he or she could certainly reopen the case and call that person in for an actual witness on his or her own authority. Rarely does this happen, but it might. And if we are talking about a fraud case, this may be somewhat important. Now, remember, you're getting the county statement of position at least 2 days before the hearing. Very often it shows up on a Friday for a hearing that's scheduled on a Monday or Tuesday. So it's going to be a busy weekend wandering your way through all of that paper, but it may be very worthwhile to do that because often, and I've seen this, I'm sure Grace has too, there are pieces of paper that show up in the county's position statement that are not very good for the county, and they didn't bother to read it before they just threw it in the pile. You will want to use that time to rework your claimant's position statement, to rework any of your questions, and to rework any of your arguments as needed. Grace?
Yeah, and one of the reasons, going back to why a witness can attend the hearing, if it's a very important witness, is that I would include a reason why the claimant can't attend. For example, if the person is in the hospital having surgery or some other really excellent reason, I would include that because it goes to the credibility of the witness. And if the ALJ realizes why the witness can't be available, he may judge the statement more credible than it would have been otherwise.
Next slide, please. You will want to draft direct examination questions and an explanation of what a direct examination is. Direct examination is when you are specifically questioning one of your witnesses. So you're questioning the grandmother, you are questioning your client. Do you share funds with your grandmother? Other than the rent that she pays me for her share on our Section 8 apartment? No, I do. Our funds are totally separate. You want to review the hearing process with your claimant and the witnesses. Tell them what the room is going to look like, tell them how the room is going to be organized, tell them how things are going to proceed. In these hearings, the county goes first, then the county's witnesses. You get to cross-examine the county's witnesses after they've done their direct examination by the county representative. And remember, the county representative is a layperson for the most part. Very rarely are they our attorneys, but if you are doing a fraud hearing, there is the chance that the person doing the hearing will be someone from the district attorney's office. So these are things you want to know before you go into that hearing. You also want to draft cross-examination questions. What is cross-examination? That is when you are questioning an opposing witness. So the very first things out of your mouth will probably be the cross-examination of the county's witnesses. It's useful to listen to how the county is doing its direct, because that will give you some hints about things that you need to develop on cross. So you want to listen carefully to any testimony, and you want to amend or modify any questions that you ask to emphasize things that are supportive to your client or to highlight areas of confusion or disagreement and show how the county statements perhaps are inconsistent. You want to review possible cross-examination questions from the county to your client. Why? Because you don't want your client to be flustered or confused, and you want to reinforce for them a very specific set of skills, which is answering a question without volunteering information. This means yes and no answers, very limited fact information. So, yes, I know that my grandmother has her own bank account. No, I don't know her bank account number. No, I do not know how long she has had that bank account. These are truthful answers, they are very clear answers, and they allow your client and your witnesses to present themselves in their best light. Oh, the judge is thinking, this person isn't trying to run around, they're not trying to play Perry Mason. They've given me very short, specific information. That works for me. Grace?
One of the issues is that the notice of, or the county position statement has at the end a list of the witnesses. So you will be able to see the identification of who will be testifying on the county's behalf. If it's somebody who's on Facebook or Twitter or something else, you might look, next door, see what that person is like. Because the whole point of the review is to try to impeach the witness. If you have a county witness who says, I've never met a welfare recipient who is not a fraud person, then you might be able to use that in your cross-examination questions. For your client, it's like, yes, no, I don't know. Unless it's like a number of times that you did something and it's 10. You don't expand upon the basic answer. The county will often not have witnesses at the hearing, so the county representative will be reading off from the statement of position. It's not within her personal knowledge. She may not know how the information was obtained by the county. And so you might be able to benefit from those type of questions. Again, impeachment of the witness is important.
Next slide, please. Negotiating is kind of a key point, and we'll probably stress that and then rush on for a bit because we are coming up on our time. We're about 20 minutes to go. The important thing about negotiating with the county representative is that the goal is a win-win outcome. Going to hearing isn't really considered a success. On the other hand, if there are points of give for both sides, this could be helpful. We've been working with a hypothetical where there's a very simple mistake of attributing a bank account to someone who does not own it, who is not considered financially part of the household, and for whom clearly a notice of action should never have been issued. And usually counties will resolve, a fact dispute like that by saying, we will withdraw the notice of action if you will provide documentation of Mary A. Smith's ownership of the bank account, the fact that it only receives her SSI income, and this can go away. Reasons for doing these stipulated settlements are because the time, the effort, and the expense of doing a hearing is costly both to your office, your agency, to your client, and it is certainly costly in terms of time and energy and expense to the county. If it's a matter of a reduction of benefits, resolving a case through negotiation may allow your client to get paid their back benefits way more quickly than waiting the 90 days to get a hearing decision, and then with the county dragging its feet to actually pay the benefits. Grace?
Nothing.
Next slide, please. So let's move into that particular fact pattern. Very simple as you read through this. Mother and daughter move to another county, move into the home of a relative. The county doesn't respond when the mother and daughter make very understandably prompt application for CalWorks and CalFresh. The mother calls and says, what happened to my application? Oh, well, it was denied and you want to come get this? And so the notice is picked up. Next slide, please. And on the face of the notice of action is clearly the problem. It's been made out to the aunt, not the claimant. And it states that we're denying your benefits because you're not residents of Forest County. Obviously, there's a problem with the address. Obviously, households, the mother and child are residents of the county. This is where they consider to be their home. And this is something the county probably would agree, let's clean this up. Next slide. So the agreement is that the county will withdraw that June 14, 2022 notice of action. The county will correct the claimant name and mailing address, G. And if the documents are provided proving that the client and her child have been living in the county as of the date of the application for aid, then the application will be granted with the appropriate proration as of June 5, 2022. You would be surprised at how many cases actually settle out this easily, but people are reluctant to rock the boat. Oh, I'll just reapply. Well, if this client had decided to just reapply, she and her child would have lost almost 4 months worth of benefits. Grace?
Okay, so when you're getting ready to go to the hearing, the negotiated settlement did not work. So the county told you we agree to disagree. The hearing itself is informal. It's in a conference room. It's not a courtroom. The claimant should dress at least business casual, but not necessary. As should the authorized representative. The hearing will be recorded for future use so that the ALJ can review the arguments of the parties. And the particular conduct of the hearing is a guideline that depends upon how the judge wants to run the hearing. There as many judges as there are at SHD, you could get the various type of procedural administrative hearings. Proceed.
Next slide, please. So just to review, the essential components of the hearing are going to be the opening statement, the direct examination, the cross-examination, and the closing statement, which are made by both sides. If it's a particularly complicated case, the ALJ may say, I have these 3 questions. I want you to write them down, and I will give you both sides a week to prepare a written closing statement. My old executive director, Gary Smith, had this line, which was, any opportunity you have to write something to a judge, you write something to a judge. It's just kind of a way of practicing. While it is not required for a client or claimant to produce a written statement of position, I find that doing a written statement of position, sort of mapping out where you're going with your presentation is helpful to the judge. In the practice of law or advocacy, written advocacy is very helpful. And since the county has the opportunity to do something in writing, you should do something as well, even if it's extremely simple. Direct examination should focus on just getting out the facts and information that your client needs. You can use cross-examination to do really the same thing. And with some experience, almost anyone can do that. Grace?
Remember that if you decide that you will probably have to writ the case, that the 1094.5 process is limited to what is in the administrative record. So if you have any evidence that might help your client, you need to include that and submit it at the administrative hearing itself. On opening and closing statements, if the county is representing one set of facts and you have found contradictory evidence in their files, you need to emphasize that both in the opening and closing and in the your own statement of position, because that will probably get you a win or on that particular fact, even if the ALJ does not notice it and rules against on that issue. The Superior Court judge will definitely notice it. Next slide.
So, with respect to the opening statement, you want to introduce your client's story. You don't want to overstate your position. Again, it's sometimes easier to do this in writing and then refer the ALJ or the hearing officer to what you've put in writing. Grace?
Go ahead. Next
slide. Okay. On direct, each party is going to try to justify their position. The county will try to justify its proposed action. The claimant's job is to rebut or counter that. You want to use open-ended questions: who, what, when, why, where. You do not want to lead the witness. You want to ask what are called open-ended questions, not too open-ended. And so you want to rehearse these with your client. You may need to refresh the client's recollection. There may be a list, there may be a statement, and the other side can ask to have that included in the record. And you want to present documentary evidence that is not already included in evidence or the record. So with respect to the bank account, you would like a redacted copy of the bank account that the grandmother has testified to. Yes, this is a copy of my bank statement. That is a very important piece of information. Grace?
Next slide, please.
Cross-examination occurs after each party has completed their direct testimony, direct examination of their witness. So you, as the advocate for the claimant, will question the county after the direct testimony is provided by the county, vice versa. You may ask leading questions. You should never ask the ultimate question, and you want to never ask a question for which you do not know an answer. Grace?
One of the things that you do not want to do is, if you have that contradictory evidence, you do not ask the county why this evidence is contradictory, because if they can't explain it away, then you've damaged your client's case. Next slide, please.
Impeachment is a process by which you, as the advocate for your client, is attempting to do the following things: identify prior inconsistent statements on the part of the county witnesses or the county itself. You want to lay a foundation to show how a mistake could have been made. You want to use any previous statements to impeach or undermine that testimony. Impeachment is very much about perception, and that goes to the personal knowledge based on the ability to see or hear. The worker says, well, it just said Mary Smith. Did you look at what the bank account number was? No. Problem. You also want to focus on issues of time. As Grace has said, could anyone have seen your client at Sac State as opposed to Chico on the morning of that she supposedly missed an appointment that she needed to make for the welfare department? You also want to look for issues of possible bias or inappropriate disregard or discrimination. Someone who says, a worker who says, well, I have a really hard time understanding Asian languages, and I just put down what I thought this person told me. All of these things are impeachment. They are qualities that undermine the statements made by the county's witnesses or staff. Next. Redirect is an optional opportunity that you have as the representative of the client to clarify testimony. You want to use this sparingly. You only want to use it when a witness's testimony is unclear or misleading, and you want to clarify when prior testimony was perhaps unclear or misleading. So the county says, well, we asked them to bring all the bank accounts, and so we were pretty sure we saw the grandmothers, and we just now noticed that. This is where on redirect, your client would be asked, were you required to provide bank accounts for your household as part of your application for CalWorks and CalFresh for yourself and your daughter? Yes. And did you provide those to the county? Yes, they are attached to this exhibit, and the county will have had to include the application, and there's the attachment. So very clearly, there's going to be a distinction between Mary A's bank account number and Mary M's bank account number. Next slide. Grace, you want to do this?
Yes. So in your closing statement, you basically reiterate what you did on the opening statement. However, at this point, you can add the facts that your client or the county testified to in order to support your closing statement. You look at all of the facts that were based on testimony. You do both the positive that your client did, emphasizing not only the testimony itself, but the documents supporting the testimony, and the county's testimony and evidence. You will say why it's not sufficient. You emphasize the legal arguments to support the claimant's position. If the action is opposite of the regulations or the statute or the ACLs, then you need to emphasize that as well. You also need to emphasize prior inconsistent statements and why the county's evidence does not support its proposed action. At this point, after the last closing statement, you can ask for the record to be left open in order to submit additional documentation, or if something had come up during the administrative hearing itself, and there was an issue that arose that you were not prepared for, you can ask to leave the record open for that to brief it and to support additional documentation. If the ALJ grants that, then the person who requested it will submit the evidence within a certain period of time, generally within 10 to 15 days. And then the other party is allowed to present their counter evidence and legal arguments. Next slide, please.
Just before we start the next slide, I did want to point out that I just lost my train of thought. Oh, well. One of the things that's really important is making sure that you have everything in the record. You want to review the ACMS file to make sure that everything you want submitted is submitted. And then we are moving on to the ALJ's decision. That decision must be based only on evidence that was presented at the hearing. This is oral testimony and argument presented during the hearing, and written argument and exhibits submitted to the judge. Just remember the thought had escaped me. Occasionally, a judge may have a question that they want you to answer in writing. Make sure that you do that. That will be often critical in cases, and as you do more complicated cases, you will begin to see more requests for input like that from the ALJ. Okay, next slide, please. So the decision itself is issued by the judge in the form of a proposed decision. That proposed decision is then formally adopted by the director of the Department of Social Services or the director of the Department of Healthcare Services if it's an IHSS or a Medi-Cal related case. It is generally due 90 days from the date of the hearing request, unless the claimant waive the time. It must be in writing and mailed to the claimant, although it will be posted on ACMS, so you can actually get them way faster than we used to in the bad old days. Anyway, it's got limitations on what it can be based on. It must provide findings and conclusions and explain why the findings lead to the specific conclusion, and it must decide all material issues of fact that were raised at the hearing. So that's one of the things that you want to make sure you do before you say, I rest my case. You want to make sure you've raised everything that you want the ALJ to make a decision on. If it is an unfavorable decision, you may request a rehearing within 30 days. So may the county, so watch out for that. There is a hard 12-month, 1-year deadline from the date the decision is actually issued, that is adopted by the director of Social Services, Department of Social Services, or the director of the Department of Healthcare Services to review, to file a review petition for a writ of mandate CCP 1094.5. What's really critical is you want to make sure you are following the rules for a CDSS or CDHS hearing, because different types of administrative cases may have different timelines for writ review. Grace?
One point, and that is if you read through the decision and you realize that there is a critical piece of evidence that was not included, I would go ahead and request the rehearing. In the rehearing request, you do need to explain why it was unavailable at the hearing. However, if you can't answer that, go ahead and request the rehearing and include all of the evidence that you failed to attach, because that becomes part of the administrative hearing record. Even if the rehearing request is denied, it will become part of the administrative record that the ALJ or that the Superior Court judge will be able to review.
All right, so we are coming up on the end of our time, but we're going to hang with you for about 5 minutes, and we will entertain some questions if you have any, which we hope you do. Going once,
And everybody's muted. So if you want to just verbally ask a question, just unmute yourself and have at it.
Okay. That, by the way, is David, who's our assistant here at CCWRO, who has been, along with Grace, a great partner in pulling this together. Okay. You have our email addresses. So if you have follow-up questions or you would like further assistance or consultation on a hearing, we're very happy to do that. We will be putting together a packet to send to you along with the tape and the slide deck.
And you will get the PowerPoint slides as well.
And if anybody would like part 2, I'm doing money and shelter money in half an hour. And thank you very much for participating and coming, and we will keep our fingers crossed as to when we finally get MCLE credit.